2022, it's a new year, and who is ready to cover the changes to the GAR contract form? So we're going to be taking a look at changes to the purchase and sale agreement and other commonly used GAR contract forms. And as a warm-up, there are a few minor changes to the seller's property disclosure statement, F301, in the sense that they added a couple of new questions. Is the property receiving preferential tax treatment as an agricultural property? Are you aware of any wildlife accessing the attic or other interior portions of the residence? And if the drinking water is from a well, it asks the seller to list the date of the last service. Some small changes: the word solar systems was changed to alternate energy systems. So GAR makes changes to their contract forms every year based on feedback from agents, case law, feedback from brokers. There'll be some super small changes. They'll change the word shall to will or will to shall. Don't worry, we're not going to cover every single one of those instances, but we are going to cover those big changes. And you'll notice today that there aren't any significant changes to the forms. It's really more clarifications than anything. But just as a reminder, Georgia is a buyer beware state. Sellers are only required to disclose latent or hidden defects with a property that a buyer could not discover on their own. And sometimes we're working with investors or folks that may just not know a whole lot about the property. They may not feel comfortable answering a full-length seller's disclosure, such as F301. One of the changes that GAR made last year was they created F302, which is seller's disclosure of latent defects and fixtures checklist. It's basically a condensed seller's disclosure form. So if you are working with an investor who maybe they've never lived in the home, consider that form because it does include the fixtures checklist, which is super helpful. So on to F201, the actual purchase and sale agreement. Now at a first glance, you may not notice any difference at all. It's still going to be 8 pages. The blanks are still going to be on pages 1, 7, and 8. But as we dive in a little bit closer, of course, the new logo with the new year will be there, but there's 2 small changes on the first page. So GAR moved earnest money in closing law firm. So now Section 5 is closing law firm. It goes immediately into holder of earnest money and the earnest money amount and the time frame for the funds to be remitted to the holder. Previous versions of the form have gone from holder of earnest money, closing law firm, and then earnest money, which could be confusing. So they have made an adjustment there. And also in terms of option money, they have added ACH, which, pop question, what does ACH stand for? Automated Clearinghouse. That has been added as a form of option money to be delivered to the seller. Now, we've had discussions in the past about earnest money versus option money. Option money is not common here in Georgia. It's not common for buyers to pay for a due diligence period, but if they do elect to do that for whatever reason, ACH is now an option for paying those funds to the seller. Now, I want to continue our discussion on earnest money here, though, because there is some change to what we call the boilerplate language, the basic terms in the contract. So, as I mentioned a moment ago, the blanks in the GAR contract are on pages 1, 7, and 8. But those other 5 pages are super important, and I can't encourage buyers and agents enough to truly go through and read that contract. But some changes to earnest money. So now there is some language added that says that the earnest money will be paid to the holder in a method of payment acceptable to the holder. So let's just say that the contract says that the earnest money will be paid to the holder by an ACH, but the holder says we only accept wire transfer. So the holder does have some power there. Also, the holder has the right now to charge the buyer for any costs associated with receiving the earnest money. I can't imagine that this will be popular. There's typically no charge for a holder of earnest money to actually hold the funds that I'm aware of, but that is now a part of the contract, that if there is a charge, the holder can elect to charge the buyer, and that charge would be collected separately from the payment of the earnest money. So they would not deduct their charge from the actual earnest money itself. Now, notice is considered received when it's actually received in that email or a fax as of the time that it's actually sent, even if it's not opened by the recipient. So that's not technically a change, it's more of a clarification, but this is going to hopefully help with some disputes, because let's just say, for example, an offer is completely accepted and notice of that acceptance is emailed over to the other agent at 11:50 p.m. one night. They don't see it until the next day. The binding agreement date is actually that calendar day that it was received, whatever date happened to be on 11:50 p.m. that night, not the next day. So even though they didn't open it, even though they did not see it until the next day, so that clarification has been included. It also goes on to talk about that the broker is authorized to accept notice for a client, but for the limited purpose of receiving notice. So, for example, notice to any of them shall for all purposes herein be deemed to be notice to the party. Notice to an authorized agent shall not be effective unless the written notice is sent to an email, fax number, or email address of the authorized agent. Broker is authorized to accept notice for a client. Any affiliated licensee of the broker representing a party in a client relationship shall be authorized agents of the party for receiving that notice. They're not universal agents. They don't have any other authority other than they're simply going to receive that notice, and that's one reason why when we are working with someone as a client, we want to send that item over to them as soon as possible so that they can review it. No authority to bind. So let's take a moment to look at this. So no broker or affiliated licensee of the broker by virtue of that status has any authority to bind any party to any contract or amendment, termination, etc. Broker shall have the right to accept notices, as we just discussed, but not send notices from broker on behalf of a party unless they are signed by the party. So we are the messenger. We may send an email and it says, hey, buyer Jane is terminating. Us sending that email does not terminate the contract. We are not a power of attorney, for example, for buyer Jane. But if we send that email with a termination notice attached to it that is signed by Jane, that's a different situation. We are now helping Jane to actually terminate. So we're not the voice, we are simply the messenger, is really what this section is clarifying here. Any broker or real estate licensee involved in the deal can perform the ministerial act of filling in the binding agreement date. It could be the buyer, the seller, it could be the agents. But if there is a dispute over that binding agreement date, it's only going to be resolved by a court arbitrator, by the written agreement of the buyer and the seller, or by the holder of earnest money, but that's limited only in making a reasonable interpretation of the agreement in dispersing the actual earnest money. Now, notice of the binding agreement date may be delivered by either party or the broker working with or representing a party. But notice this new language here. So, notwithstanding any other provision to the contrary, it is the express intent that broker or licensee involved in the transaction may perform the task of filling in the binding agreement date, sending a fully signed purchase and sale agreement with a specific binding agreement date included that one of the parties has agreed to constitutes notice of the binding agreement to the other party. But let's talk about when there is an objection, when we think that that binding agreement date is not accurate. So if the buyer or the seller objects to that binding agreement date, they have 1 day from receiving notice of the binding date to object. Now that objection will only be resolved by the written agreement, the written amendment between the buyer and the seller. And there is a form that GAR has specifically for this purpose. That's F733. Now it goes on to say the absence of an agreement on the binding date shall not render the agreement unenforceable, but the failure of a party to timely object will result in the parties accepting the binding agreement date as entered. So time is of the essence here is really what GAR is getting to. You receive that binding agreement date back and you feel that binding agreement date is wrong, you've got 1 day to provide notice of that and try to get that issue resolved. Now, when it comes to handling conflicts, when there are terms in an agreement that conflict one another, how do we decide which term prevails? So this is a formula that GAR is now setting forth on page 6 of the purchase and sale agreement. And this really hasn't changed, so handwritten changes do control over pre-printed or typed provisions of the contract. Exhibits control over the main body, and special stipulations are king. But what GAR did is they went ahead and included a section 4, and I am going to read this. It says, any amendatory clause in an FHA or VA exhibit shall control over inconsistent or conflicting provisions contained in a special stipulation, another exhibit, or the main body of the agreement. So what are we really saying here, and why did GAR add this? So the amendatory clause in an FHA or a VA financing exhibit, that is the appraisal contingency. And it's a blanket appraisal contingency, meaning that it runs the entire life of the contract. It's not limited to any specific number of days. It's a blanket appraisal contingency. We cannot override that. That's a lender requirement ultimately. So even if we include a special stipulation and include something such as an appraisal gap clause and say that if the property doesn't appraise for the contract purchase price, the buyer is going to pay the difference. We cannot override that amendatory clause that basically says that the property doesn't appraise, the buyer doesn't have to buy the home. And if they terminate because it did not appraise, they are entitled to a refund of their earnest money. So just be careful with that. That was a question that has come up over the past year or two just because of the extreme seller's market that we're in and with the rise of, or the popularity of, appraisal gap clauses. If it's FHA or VA, that amendatory clause is going to control. Now, another thing that GAR did this year, which was a clarification, and I think this is going to be very helpful, is they go ahead and define a day. They say, for the purposes of this agreement, the term day shall mean a full calendar day, ending at 11:59 p.m., except as may otherwise be provided. Could be a special stipulation added to end that day at another time, but usually not, so it's going to run through 11:59. It says, for the purposes of counting days for determining deadlines, the specific date referenced as either the binding date or the date from which the deadline shall be counted will be day 0. So let's take, for example, let's just say that the binding agreement date is the 1st of January, and there's a 5-day due diligence period. The due diligence period would expire at 11:59 p.m. on January the 6th. So here's a little bit closer example of that. The binding date is the 1st of January, and that would be considered day 0. 1, 2, 3, 4, 5, all the way through 11:59 p.m. And those time frames are super important, especially with due diligence, because as we know, right, a buyer can terminate for any reason at all during their due diligence period. Financing contingency, appraisal contingencies, those time frames are so important. All right, so we're moving on from the purchase and sale agreement. So most of the changes, as you can see, they are clarifications. They're in the body of the contract itself. Really weren't any changes to the blanks, just a little bit of reordering on that first page. But let's talk about a change to F110, and that is the exclusive buyer brokerage engagement agreement. And that is in terms of commission. So years past, the buyer brokerage agreement has had set up on the very first page a section that says that the broker is entitled to a certain amount of commission, and that it's customary for the seller to pay it, and if the seller doesn't pay it, the buyer shall or shall not pay the difference. So due to the extreme change that we have seen in the market, and in some instances where the commission being offered to buyers brokers is less than what we have seen historically, and in some cases zero, GAR revised their buyer brokerage agreement. So now it just is pretty straightforward. It says this is the commission that the buyer is going to pay to the buyer's broker at closing. And that's going to be less minus any commission received from the seller or the seller's broker. So for example, if we were to state 3% and we actually receive 3% commission, the buyer won't owe anything. If we were to state 2% or 1% and we receive that amount or greater, the buyer won't owe anything. However, if we state an amount there, let's just say 3%, could be a dollar amount, right? And we don't receive at least that much. In that instance, the buyer would owe the remainder of the buyer would owe the balance. Now keep in mind though that the buyer brokerage agreement, just like any other agreement, can be amended. So there is a specific amendment form that GAR has for amending a buyer brokerage or a seller listing agreement. It's called Amendment to Brokerage Engagement. So it could always be changed theoretically if the agent at the broker and the buyer agreed to make that change. Appreciate the fact that GAR has increased their warnings to buyers when it comes to buying property sight unseen. I think most of us know the obvious risk in doing that, but I love how GAR has really just explained this to the buyer, because photographs, videos, other information about the property, it's just not the same as actually visiting the property for yourself. And again, Georgia is a buyer beware state, so the duty is on that buyer. Now there was some language added in the default section just to clarify that the buyer would still owe commission even if they close on a deal that begun during the term of the agreement but closed after. So that has been clarified for buyers. Now let's move on to the conventional financing exhibit, and this is F404. And the changes here, they added some language to state that the lender not having completed underwriting is not a legitimate reason for a loan denial. Also, if the property did not appraise for the purchase price, unless the contract was contingent on an appraisal contingency, that's not a valid reason to terminate the contract. It's not a valid reason for the loan denial letter. And if the loan denial letter is based solely on those reasons, the buyer most likely is going to lose their earnest money. And let's also talk about the temporary occupancy agreement F222. So this is in regards to personal property repairs, and language is added to just clarify that the seller is required to remove all of their personal property from the property prior to the occupancy by the buyer. Now, of course, if there's a bill of sale or some other agreement that the seller is going to leave certain things, those items should stay. And it also clarifies that the buyer is responsible for making all repairs to the property, excluding damage caused by the seller and others under the control of the seller. So this is a change to the seller's temporary occupancy agreement. I do want to clarify that, not the buyer's. So at this point, just keep in mind, the buyer has closed. It is their property. They are the owner. So of course they're responsible for making those repairs to the property. Not a big fan of a buyer moving in earlier for obvious reasons, or a seller remaining in a home after closing. I hope that this helps. Thank you so much for watching and for being here with us. If you haven't already subscribed to our channel, consider doing that. We'd love to have you as a subscriber. Please feel free to like and share, and we appreciate you.